Friends, let us solve one more question. That is question 9, which was in the Advocate on Record examination of paper 1, 2019. It says, briefly explain the procedure for filing an SLP appeal on behalf of an indigent person. Is the Supreme Court Rules 2030. Describe the concession available to the indigent person under the said rules. So this was the question which I am going to solve, friends. As far as appeal as an indigent person is concerned, Supreme Court Rules 2013, Order 18, describe the procedure, that is, appeal and application by indigent persons. Rule 1 says that an application for leave to proceed as an indigent person shall be made on a petition. It shall be accompanied by a copy of the petition of appeal and documents referred to in Rule 3 of Order 19, or of the petition for special leave and documents mentioned in Rule 4 of the Order 21, as the case may be. These orders I am also stating in the last para of this video. An affidavit from the petitioner disclosing all the property to which he is entitled and the value thereof, other than his necessary bearing, apparel, and his interest in the subject matter of the intended appeal, and stating that he is unable to provide security or surety for the cost of respondent and court fees. The registry shall, on satisfying himself that the petition is in order, direct that the petition shall be registered and set down for hearing before the chamber judge on the date to be fixed for the purpose. The application shall be posted before the judge in chamber, who may himself inquire into the indigency of the petitioner after notice to the other parties in the case, or to the Attorney General, or make an order directing the High Court, either by itself or by court subordinate to the High Court, to investigate the indigency after notice to the parties interested, and submit a report therein with such time as may be fixed by the order. On receipt of the report, the petition shall again be posted before the judge in chamber for further orders. Provided if the applicant was allowed to sue or appeal as an indigent person in the court from whose decree the appeal is preferred, no further inquiry in respect of his indigency shall be necessary, unless this court sees cause to direct such inquiry. In granting or refusing leave to appeal as an indigent person, the court shall ordinarily follow the principles set in Order 33 of the Code. Code means Civil Procedure Code. Where a petitioner obtains leave of the court to appeal as an indigent person, he shall not be required to pay court fees on the documents filed in the case or fees payable for service of process. He shall, however, be required to pay fees for obtaining copies of any documents or orders. The judge in chamber may assign an advocate on record to assist an indigent person in the case, unless the indigent person has made his own arrangements for representation. Such assignment shall only be from the panel of advocates willing to assist indigent person and chosen by the judge in chamber. It shall, however, be open to the judge in chamber in his discretion to assign an advocate outside the panel in any particular case. No fee shall be payable by an indigent person to his advocate, nor shall any such fees be allowed on taxation against the other party except by an order of the court. The advocate may, however, receive from the indigent person money for out of his pocket expenses, if any, properly incurred in the case. It shall be open to the court if it thinks fit to award costs against the adverse party or out of the property decreed to an indigent person and direct payment of such costs to the advocate for the indigent person. Save as aforesaid, no person shall take or agree to take or seek to obtain from an indigent person any fee, profit, or reward for the conduct of which case. And any person who takes, agree to take, or seeks to obtain any such fee, profit, or reward shall be guilty of contempt of court. Soon after an appeal by an indigent person has been heard and disposed of, the advocate for the indigent person shall file in the registry a statement of accounts showing what money, if any, were received by him in the case of on any account from the indigent person or from any person on his behalf and expenditure incurred. If no money had been received, a statement shall be filed to that effect. The taxing officer may, where he thinks it necessary, place the statement filed before the judge in chamber for his perusal and order. Where the applicant succeeds in the appeal, where the appellant succeeds in the appeal, the registrar shall calculate the amount of court fees which would have been paid by the appellant and if he had not been permitted to appeal as an indigent person and incorporate it in the decree or order of the court. Such amount shall be recoverable by the government of India from any party ordered by the court to pay the same and shall be the first charge on the subject matter of the appeal. Where the appellant failed in the appeal or permission granted to him to sue as an indigent person has been withdrawn, the court may order the appellant to pay the court fees which would have been paid by him if he had not been permitted to appeal as an independent person. The central government shall have the right at any time to apply to the court to make an order for payment of the court fees. Where the party not represented by an advocate of his choice, the court may, in a proper case, direct the engagement of an advocate from the panel of Supreme Court Legal Service Committee or at the cost of state. The fee of the advocate engaged at the cost of the state shall be such as may from time to time be fixed by the Chief Justice unless otherwise or directed by the court. After the hearing of the matter is over, the registrar, the additional registrar, or the deputy registrar shall issue to the advocate where engaged at the cost of state a certificate in the prescribed form indicating therein the name of the said advocate and amount of fees payable to him. The state concerned shall pay the fees specified in the certificate issued under above order, above rule to the advocate named within 3 months from the date of his presenting before it for claim for the fees supported by a certificate. If the fees are not paid within the period above said, the advocate is entitled to recover the same from the state concerned by enforcement of the certificate as an order as to the costs under the Supreme Court Decree and Order Enforcement Order 1954. For the purpose of this rule, the term state shall include union territory also. All matters arising between the central government and any party to the appeal under the preceding rule shall be deemed to be question arising between the party to the appeal. In every appeal by an indigent person, the registrar shall, after the disposal thereof, sent to the Attorney General for India a memorandum of the court fees payable by the indigent person. No appeal or other proceedings begun, carried on, or defended by an indigent person shall be compromised or discontinued without the leave of the court. Any respondent who desire to defend may be allowed to set up the defense and an indigent person, and rules contained in this order shall apply to him as if he were a petitioner moving the petition for leave to proceed as an indigent person. Now, friends, there is mention in this order that a rule 3 of order 19 will apply. Now, I am reading out rule 3, what it says. The petition shall recite sequentially and in chronological order with the relevant dates, the principal steps in the proceeding leading up to the appeal from the commencement thereof till the grant of certificate of leave to the appeal to the court, and shall state the grounds on which the judgment under appeal is assailed, as well as the amount or value of the subject matter of the suit in the court of first instance and in the high court, and amount or value of the subject matter in dispute before the court, with particulars showing how the said valuation has been arrived at. Where the appeal is incapable of valuation, it shall also be so stated. The petition shall be accompanied by a certified copy of judgment and decree or order appealed from, certificate granted by the High Court, and the order granting the said certificate. In cases where, according to the practice prevailing in the High Courts, the decree or order is not required to be drawn up, it shall be so stated upon affidavit. In appeals falling under any of the categories enumerated in Rule 6, in addition to the documents maintained above, a certified copy or uncertified copy, if such copy is affirmed to the true copy upon affidavit of the judgment or order, and also of the decree of court immediately below, or such a copy of the order of the tribunal, government authorities, or person, as the case may be, shall also be filed with the appeal before the appeal is listed for hearing ex parte. At least 7 copies of the aforesaid document shall be filed in the registry, where at any time between the grant by the High Court of the certificate for leave to appeal to the court and filing of the petition of appeal, any party to the proceeding in the court below dies, the petition of appeal may be filed by or against the legal representative, as the case may be, of the deceased party, provided that the petition is accompanied by a separate application duly supported by an affidavit praying for bringing on record such person as the legal representative of the deceased party, and setting out the facts showing him to be the proper person to be entered on the record as such legal representative. The registrar, after satisfying himself that the petition of appeal is in order, shall endorse the date of presentation on the petition and register the same as an appeal in the court. Where the party desires to appeal on grounds which can be raised only with the leave of the court, it shall lodge, along with the petition of appeal, a separate petition stating the grounds so proposed to be raised and praying for leave to appeal on those grounds. Friends, there is also mention of Order 19, Order 4, Order 21, Rule 4, in case the SLP civil is filed. So, friends, I am reading out what the Order 4, Order 21, Rule 4 says. The petition shall be accompanied by a certified copy of the judgment or order appealed from, and affidavit in support of the statement of the facts contained in the petition. So, after the formalities are completed, the person can sue as an indigent person. That's all. God bless you all.